Hello everyone, today we'll discuss Article 1277 of the Civil Code, which talks about confusion in joint obligations. But what does that really mean? Let's break it down in simple terms. Article 1277 states that confusion does not extinguish a joint obligation except for the share of the creditor or debtor in whom both rules merge. In simpler terms, if a debtor and creditor become the same person for a portion of the obligation, only that part is extinguished. The rest of the obligations remains in effect for the other debtors. Let's look at an example. Suppose Aida, Lorna, and Fee owe Johnny 30,000 pesos, of each of them is responsible for 10,000 pesos since it's a joint obligations. However, before Johnny passed away, he made Fee his legate for 10,000 pesos. This creates confusion because Fee is now both a debtor and a creditor for her share. This means Fee's share of 10,000 pesos is extinguished, but the rest of the debt doesn't disappear. Aida and Lorna still need to pay Johnny's state their 10,000 pesos each. In short, confusion only cancels the portion where the debtor and creditor merge. It doesn't erase the whole obligation, so Aida and Lorna must still settle the remaining debt. This principle ensures fairness in financial obligations.
Section 5 Compensation. Article 1278. Compensation shall take place when two persons in their own right are creditors and debtors of each other. Example: A owes B the amount of 5 pesos. B owes A the amount of 5 pesos. Two persons here are the debtors and creditors to one another. The first obligation is A owes B 5 pesos. A is the debtor, B is the creditor. The second obligation, B owes A 5 pesos also. B is the debtor and A is the creditor. Kinds of compensation. There are two kinds of compensation, by its effect and by its cause. Under the by its effect, total and partial. Total, when both obligations are of the same amounts. Partial, when the two obligations are of different amounts. Let's proceed by its cause. First, legal compensation, when it takes place by operation of law. Second, voluntary or conventional compensation, when it takes place by agreement of the parties. Third, judicial, when it takes place by order from the court of litigation. Fourth, facultative, when it can be set up only by one of the parties. Let's proceed to Article 1279. In order that compensation may be proper, it is necessary, first, that each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. Second, that both debts consist in a sum of money, or if the things due are consumable, they be of the same kind and also of the same quality if the latter has been stated. Third, that the two debts be due. Fourth, that they be liquidated and demandable. Fifth, that over neither of them there be any retention or controversy commenced by third persons and communicated in due time to the debtor. Absent any showing that all of these requisites exist, compensation may not take place. Let's proceed to Article 1280. Notwithstanding the provisions of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. Example: A owes B 100,000 pesos. C guarantees A's debt to B. B also owes A 50,000 pesos. In this case, C, the guarantor, can use compensation to reduce their liability. C can argue that B should offset the 50,000 they owe A against the 100,000 pesos that A owes B. This would reduce C's liability to 50,000 pesos. This article is an exception to the general rule that guarantors are fully liable for the principal debtor's debt. Let's proceed to Article 1281. Compensation may be total or partial. When the two debts are of the same amount, there is a total compensation. So I discussed this earlier about the total compensation and partial compensation. Total compensation when the two debts are the same amount, while partial compensation are of different amounts. Example, A owes B 100,000 pesos. B owes A 100,000 pesos also. In this case, there is total compensation because the debts are of the same amount compensation. Example of partial compensation, A owes B 150,000. B owes A 100,000 pesos. In this case, there is partial compensation because the debts are of different amounts.
Article 1282. The parties may agree upon the compensation of debts which are not yet due. So, ang duha ka partido mahimong magkaudyon sa pagbayad sa utang ngawa pa sa panahon sa tigsukutay. So, compensational or voluntary compensation. So, it means it occurs when the parties agree to the mutual extinguishment of their credits or to compensate their mutual obligations even in the absence of some of the legal requisites. Article 1283. If one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to said damages and the amount thereof. So, ang usa ka partido sa usa ka suit sa obligasyon na ay karapatan para sa mga pinsala laban sa usa. Ang nauna ay maaaring ipawalang bisa ito sa pamamagitan ng pagpapatunay ng kanyang karapatan at sa nasabing mga pinsala at halaga nito. Article 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. Article 1285. The debtor who has consented to the assignment of rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assigner, unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignments. Okay. So, what is assignment of rights? The transfer of rights, especially contractual rights, from one party to another. Article 1286. Compensation takes place by operation of law. Even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. So, compensation by operation of law, indemnity for expenses of transportation, this apply for the transportation of goods or of an object.
Article 1287. Compensation shall not be proper when one of the debts arises from a deposit or from the obligation of a depositary or of a bailee in communitum. Neither can compensation be set up against a creditor who has a claim for support due by gratuitous title without prejudice to the provision of paragraph 2 of Article 301. So this means when someone is given something that belongs to someone else, their job is to keep it safe and return it in the same condition. So, kita hay nahuwam kag umbrella sa imong amigo. So, di ba, if nahuwam ka, you're expected to take care of it and give it back as you receive it. For example, also if you have given money to someone to keep it safe, but it happens nga nakautang kay ngadto nga tao, then moingon si nga i-deduct ni Diya katong imong utang sa katong imong gipagunitan. So di po na pwede. It should be meant to be held and returned exactly as it was given. So di ni Diya pwede i-deduct ang katong imong utang sa katong imong gipagunitan. So there are also debts which cannot be compensated. So in Article 1288, neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. So this means that if someone owes money because they committed a crime, they must pay it in full. They cannot cancel it out with another debt. So there are debts that cannot be compensated. First is debts arising from contract of depositum. If someone is keeping money or an item for safekeeping, they must return it exactly as it was. For example, if nakaygipagunitan nga 10K sa imong amigo, later on, nakautang po kag 5K sa imong amigo. Then, moingon na imong amigo nga 5K na lang ang ibalik nga sa katong imong gipagunitan kay naman kay utang nga 5K na ho. So di na pwede. Why? Because they are trusted to return your full 10,000 and not use it to settle other debts. So second is debts arising from contract of commoditum. So if someone borrows something for fee na kay gipahuwam, so it's their obligation to return it as it was. For example, if you borrow your friend's laptop for a week, but you remember that your friend owes you 10,000 cash, then di ka pwede maingon nga ako na lang ning laptop nimo kay naman kay utang na ako nga 10K. Di na pwede. Because the deal was to borrow it and return the laptop and not given as a payment. So you must return it as promised and not let your friend pay her debt separately. Third is claims for support due by gracious title. If someone is entitled to pay financial support or child support, they must receive it in full. For example, a father is entitled to pay 10,000 monthly of child support, but ang katong iyang anak is nakautang og 3K sa iyang papa, then maingon iyang papa nga kuhaan na lang ang katong 3K ni iyang utang sa 10K. So di na pwede. Because it should be meant for basic needs and not pay it for some debts. 4 is one of the debts consists in civil liability arising from a penal offense, debts from a crime or from a penal offense. If someone is punished by law and ordered to pay damages, they must pay in full. For example, a reckless driver damages a car and owes 50,000 in repairs. The car owners also own the driver 20,000 from a different transaction. So, di mo nga nag-driver nga, I'll just pay 30,000 because you owe me 20,000. So, di po na pwede. The 50,000 is a penalty from the wrongdoing. So, di na pwede niya kuhaan from a different transaction. So in Article 1289, if a person should have against him several debts which are susceptible of compensation, the rules of the application of payment shall apply to the order of the compensation. In Article 1289, if a person should have against him several debts which are susceptible of compensation, the rules on the application of payment shall apply to the order of compensation. So this means that if a person owes several debts, kanang daghan na kaadyong utang, that can be cancelled out or compensated against what they are owed, the same rules are paying debts will apply to decide which debts would get cancelled first. For example, client A own client B 10,000, 20,000, and 30,000 from different transactions. But client B also owes client A 25,000 from another deal or transaction. Since some of these debts can cancel each other out, we follow the rules of payment priority to decide which debt gets settled first. So, unsaon na, if there's an arrangement, mo to ilang sundon. If not, o kinsa to'y murag pinaka-old nga debt, mo to ilang unhon o settled. If they have the same due date, the one that benefits the debtor most is cancelled first. When someone has multiple debts that can be cancelled out, we apply the same logic as when deciding which debt to pay first. This is to ensure fairness and proper handling of debts. So in Article 1290, when all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount even though the creditors and debtors are not aware of the compensation. This means that if all the requirements in Article 1279 are met, then the debts automatically cancel each other out by law, without needing any action or agreement from the people involved, both debtor and the creditor. For example, if person A owes person B 10,000 at the same time, person B also owes person A 10,000. Instead of both of them paying each other, the law says the debts cancelled out automatically. So even if person A and person B don't talk about it or don't realize about it, legally speaking, they no longer owe each other anything. So may pasabot ani. So yung ani. The law automatically balanced debts that met all the conditions to make things simple and clear. So instead of requiring both sides to go through the process of paying each other, the people involved don't need to do anything. The debt simply cancelled out up to the amount of that matches. So if the debts are not equal, only the matching amount is cancelled and the rest must still be paid. And that's it for chapter 4, section 5.